Good afternoon, everybody. It's a big pleasure being here in this wonderful venue, and I'd like to start off by thanking the organizers, Sultan and Betty, for another wonderful job they've done in organizing another splendid conference. So you are already aware of the setting. We have a fireside here, and you might be wondering what this is. So by no means I have not invented this format. This format is actually several decades old. But I've introduced it to this conference series in order to be able to deepen certain key regulatory aspects that are key to the industry. And we normally have highly distinguished guests for this format, and I'm extremely pleased to have today, please Michele, Michele Magro, who is the Chief Counsel of the Malta Gaming Authority, and as such also in charge of policy questions and international affairs. So Michele is extremely knowledgeable about anything related to policy making, how to translate it in a sound way to regulation, and of course the international larger picture of it. So just to say a few words, Michele has extensive experience. He has been more than 7 years with MGA. He has seen many changes. He has seen several CEOs also at the authority. So if you want, so Michele is somehow the institutional conscious of the MGA, who has been there for a long time and who is very familiar with the old system, but also with the new legislative system in Malta. Michele Magro is also a board member of GREF, the European Regulators. And again, I'm particularly pleased to have you here today. Thank you very much for coming.
Thank you. And something I'm not very good at is microphone. So thank you for the introduction, Simon. Very kind words. My job at the MGA is Chief Counsel on International Affairs and Policy. So effectively my job is to, first of all, be the main liaison between the Gaming Authority in Malta and our counterpart regulators elsewhere in the world, especially Europe, but also beyond Europe. And secondly, my job as Chief Policy is to make sure that when it comes to new areas of development, horizon scanning is what we call it, that the MGA is ready for what's coming next. We spoke about innovation in the previous panel. We actually have an innovation team at the MGA. We look at what's coming up. We as much as possible, try and as much as possible attend conferences and seminars and demos on new products that, for example, help out in terms of automating KYC and that sort of thing, to essentially know what's coming up. So nowadays, compliance and regulation in general is so complex that you need innovative tools on how to do it. Before we were saying it's a question of how regulators would allow certain instruments such as artificial intelligence in compliance and so on. Well, I would say that in this day and age, without certain innovative ways of how to actually conduct compliance, you'll actually be lost.
And of course, in the case of MGA, you're in the privileged situation to have sufficient staff. I believe you're the second largest authority in Europe after the UK, with 170 staff. That's of course a very significant authority. So maybe as a starting point, could you tell us a bit more about, considering the new legislation in Malta, considering the new regulatory approaches, what are the big lines? What's the vision of the authority under this new regime?
Okay, so for those who maybe do not know, after 14 years of regulated online gambling, last year we essentially repealed all gambling laws in the country and replaced them with new ones. And I think the primary motivation behind that was to actually take lessons learned over 15 years. The truth is that the law did not survive 15 years. As we were saying before in the previous panel as well, law always lags behind technological development and even social developments and the political situations, let's put it that way as well. So the question was to actually implement new forms of regulation, take lessons learned. I mean, one of the principal things was risk-based regulation and objective-based regulation. So the role of the regulator, as we see it, is not to say, for example, to define the rules of blackjack or to define the rules of poker. Those rules are defined by the market, by the players, and by the operators. They're not defined by us. Our role is to identify what risks that certain products expose consumers and the whole system to, and create rules that cater to those systems. So our law, our LUNIO especially, is designed to be as much as possible technologically neutral and game neutral. So if you want to offer any type of game, you can actually do that. What we will do is we get our staff to look at the games and see what risks that those specific games expose to the industry. But the whole question is allow as broad a spectrum of games you can, so that consumers are channeled towards a regulated and as much as possible an attractive offer, but at the same time, catering for the risks of each and every game. So yeah. If I had to use an example, take one of the newer products that's very popular out in the market right now, betting on lotteries. So it's very different to traditional lotteries, and also very different to betting in terms of the risks that the specific product exposes. For example, how to ensure prize pools amounting to 200 million and so on. So that is something that the MGA had to sort of analyze. So we go in deep into the question of how to make sure that 200 million euro prize pool is sufficiently covered. So we look at everything from the insurance contracts and make sure everything is as much as possible ironclad.
So would it be fair to say that, in a way, the larger way you look at these games is really using a risk-based approach? I'm putting that notion forward because the risk-based approach is usually a notion just used for AML, right? Yeah. And is now a big buzzword, of course, for the last few years. But would that be fair to say that this is really the larger line you look at things, a risk-based approach, any kind of risk?
Yeah, so if it's a question of economic risk, it can be criminal risk, it can be a number of different risks. So yes, it's true that the FATF, actually risk-based methodology, is sort of the basis of most of what we do, but it's just how to tweak the methodology to specific risks of the industry.
Let's give maybe an example. You mentioned economic risks, yeah. And I believe when preparing this Fireside, we have mentioned lotteries. Could you illustrate that? What an economic risk in relation to lotteries could be?
So lotteries is, one could say, quite a saturated market. Okay, it's a very traditional product and has a very a set player base. Compare it to, for example, poker. Lotteries is high risk in terms of from an economic point of view, because the probability of a company not being able to meet its financial targets and eventually collapse are higher than, for example, a poker product. So, and that's from a perspective of volumes and so on. However, poker, on the other hand, has a higher risk from an AML point of view. So, it's a question of treating two different products in the way that applies to that specific game type. So if it's a question of AML, lotteries are treated right here, while poker is treated up here. However, when it comes to economic risk, so financial stability of the company, if it's a question of, if we're vetting a company, we'll look at a lottery company, we'll look at, for example, the experience that the team behind it has. Why? Because if it does not have an experienced team, if it's just an amateur trying to create a new lottery, the very likelihood is that it's going to fail. So when it comes to an economic assessment, lotteries will be subject to a higher standard than poker companies.
This sounds very sound indeed. So just to illustrate, I understand when you mention higher AML risks in poker, you probably allude to the fact that you have a peer-to-peer situation, and in a peer-to-peer situation, a party might decide to collude with another party, say to lose voluntarily, and thereby maybe engage in activities that might not be legal. So I think this has been very clear and sounds very logical to approach things like that, and it's unfortunate that many jurisdictions don't have such a view. There are 4 categories of games under the Maltese logic. One of them is our skill games, and we'll have the opportunity to talk a bit more in a moment. But before we come to that, can you outline a bit more about the methodology of the new approach in Malta?
Okay, so effectively, the reason why we changed the law itself is also certain other concepts, such as, for example, technological convergence. I mean, obviously, we're not, I mean, as the MGA, we're mainly known for online gambling regulation, but we also have land-based casinos and outlets and so on that we regulate in our own specific territory. So what we were seeing, for example, is technological convergence. The same games that are offered online are offered on a land-based point of view. So when we were designing our new law, we designed it in a way that as much as possible, there are similar checks imposed. There obviously will need to be differences. I mean, a key element of differing the regulation between land-based and online is that land-based require a cornerstone of it is accounts, gaming days, closing and opening, and so on, which doesn't exist in online. Online keeps on going. So the law needed to be designed in such a way that it would cater for a number of different channels and games, but as much as possible keep it a singular license and as much as possible a horizontal baseline for regulation, if you know what I mean.
I did mention skill games. That's the category 4 in Malta. Could you elaborate why it may make sense to regulate skill games as well? I'm raising this question because in quite a few jurisdictions, the general rule is either something is gambling, considered games of chance, and then it's heavily regulated, or it does not meet the gambling test, and then it's hardly regulated at all. So why does it make sense to actually regulate games of skill?
So it depends really, really and truly on the exposure, the risk exposure to the customer and the risk exposure to the system, the criminal risks of the system. I mean, previously I mentioned that poker is at a higher risk of money laundering, for example. Skill games actually are as well. At the same time, however, the volumes that we see in skill games, the volume of money that's being used is very different to what we see in traditional gambling, including poker. So it's all a question of assessing the risk that a specific activity is posing towards society at large, whether it's the consumer or the financial system, you name it. As things develop, it's obviously extremely important for a regulator to keep an eye on what's upcoming. So if this conference were happening 3 years ago, we would actually be talking about fantasy sports. Nowadays, not so much, perhaps, and that's, I guess, market forces at work. But the whole point behind the regulator is sort of they need to have a finger on the pulse. They need to know what's going on and what's coming next, and basically to create regulation that caters for the specific risk. So the truth is, if we had to come up with skill game regulation that was identical to traditional gambling, it would never work. The role of the regulator is not to define an economic model. The role of the regulator is to define the risks and to cater specifically for those risks. If I had to take if I had to regulate skill games in the exact same way as I regulate casino, that would just not work. It would just kill the business. And it's actually in quite a few laws of member states that it's not just our job to regulate the market, to protect consumers. It's also our job to make sure that there's public faith in the gambling industry. It's also our job to make sure that the public trust how the government regulates gambling, and that gamblers and players in general, not just gamblers, actually trust who they're playing with. So, and also economic stability and financial stability of operators. Ultimately, operators are employing people. They're, people's lives depend on the employment by gambling companies and gaming companies. So ultimately, that's also a consideration that needs to take place. There needs to be a certain level of stability. So, and this goes even into the methodology of how the regulator works. We need to consult before introducing new things. It's not just a question of, overnight saying, okay, by tomorrow you need to close all your skill games, for example. I mean, you're playing with people's lives ultimately. So
when you mention public faith and trust, I'm under the impression that this might have been an underlying reason why in the UK the industry has been struggling the last couple of years, only mentioning advertising issues, right? There seems to be the support of certain key public stakeholders seems to be, let's say, questioned. Would you agree on that?
Yes, definitely. So, and I think this is why actually regulation benefits operators in general, because ultimately regulation needs to be good enough that the people out there, so basically the voters who's voting for the politicians, actually believe that there is a sufficiently comprehensive system. If it's not the case, I mean, the results that we're seeing throughout Europe is the consequence. So if you're taking all of the advertising restrictions that are coming up in the UK, in Spain, in Italy, and so on, that's a result of lack of public faith in the system. And as a result, regulators are normally pressured by politicians to essentially up their game, to increase the standards. So, and that is why regulators in general tend to be a bit tough-handed sometimes, because ultimately that is one of their objectives. And it's actually a question of ebb and flow as well, because public faith moves around and changes. So there are instances where the regulator can afford to be soft-handed. There are instances where the regulator needs to be a lot more stringent.
This is quite a pan-European phenomenon. I believe that we have seen politicians coming forward and asking essentially their national regulator to be stricter and to do something. Often this something is not very clear, but the claim is often to do something about problem gambling, to do something about too much advertisement. And then, as you say correctly, regulators come under pressure to do indeed something. Then on some occasions this something may be more sound than in others, but we have definitely seen this phenomenon, say, in the Netherlands, in Italy, in the UK, and so on.
And ultimately, that's why self-regulation, to a certain degree, is also a good idea, because it's a question of not triggering a negative public reaction. So basically, if operators stopped doing, the bare minimum for them to be legal, but try to do something more than what the law actually prescribes, and so go above and beyond and create their own standards, then the less attention you're going to essentially derive from the public and the politicians. If there are major scandals and it just takes one, then the reaction will be tougher regulation. So it's all a consequence of past instances.
Almost unavoidable, yeah. So we didn't mention skill games. You're in the fortunate position in Malta to have a regulation that gives you quite some leeway, quite some discretion, meaning to MGA how to apply the rules. How does esports fit in your regulatory approach? How do you handle esports?
So esports on itself might not be a full competence of a gambling regulator in the first place. If it's a question of betting on esports, that's very clearly within the competence of the gambling regulator, because ultimately betting on the outcome of an event, whether it's an election, a sports event, an esports event, it makes no difference. It's ultimately the same economic activity. So that is something that falls completely within the regulator's remit. On the other hand, esports and video games themselves create, I guess, different challenges. There is addiction, which is something that the health authorities would be concerned about. There's a consideration of health and so on that perhaps the sports ministries and so on that would actually get into it. So it's actually quite a cross-sector challenges to esports. And then there's obviously the elephant in the room, which are gambling elements within video games, and such as loot boxes and so on. So that is actually a major issue for discussion across gambling authorities, but also consumer authorities within Europe. Most regulators are tied to their specific definitions of law. So our law and most countries around the world are restricted in as to what they can do. At the same time, for example, we also act as policy advisors to government. So we actually conduct studies, and ultimately we advise government on what the main risks are, but not necessarily something that we need to take action on. So if it's a question of that loot boxes are dangerously treading into gambling territory, it's a question that we might inform the government about. We will inform the government about it, and we'll say, but listen, it doesn't meet the parameters of gambling. It does not necessarily meet the parameters of gambling. I mean, obviously, the parameters of gambling are very, very normally like three things, which is consideration, the prize, and the element of chance. Loot boxes do not always meet those three criteria, so it might not be categorized as gambling.
Exactly, and I'll come back to these three criteria in a moment. Since we have the privilege of having Michele Magro with us, I just want to briefly reach out and see whether somebody from the audience has a question to our guest, maybe on some of the topics that we have covered so far. Yes, please.
Well, probably because we're very close traditionally to the Gambling Commission in the UK, but that's also because obviously it's one of the more mature markets, and we share a lot of mutual licensees. So it's a question of exchange of information. The Gambling Commission in the UK is one of them, but traditionally we cooperate with most jurisdictions in Europe, whether it's Sweden now, especially the Netherlands, Italy, France. Spain. I mean, it's yeah.
Very briefly.
Well, we explored that route, to be honest. However, we understand that from a testing point of view, we actually already accept certificates issued according to those standards, according to the IAGR standards. The issue is that standard was meant to also include game testing, but that has not materialized yet. So what we're doing is we're hoping to create our own standard that incorporates pretty much exactly what the IAGR standard. I mean, when we create new requirements, we as much as possible try to adopt already existing international standards, because one thing that we are very conscious about is duplication of compliance checks. It's actually in our law that when we approach our policy-making initiatives, we should, as much as possible, not duplicate something that already exists. So if it's a question of, for example, information security, if it's a question of RNG testing, we look at what is already out there in the market. We look at what most operators that are licensed in other countries have already complied with, and we, as much as possible, adopt that exact same thing, because it actually pays no one, except maybe some testing labs or some consultants, to have operators just undergoing further tests that cost hundreds of thousands of euros, just to say you have an extra piece of paper that has no practical effect.
Okay, I believe we will have to wrap it slowly up, and I'll come to my last question, and then I think this is last point standing between us and the lunch for everybody. Some jurisdictions don't practice a predominance test. So they apply their gaming laws irrespective whether there's an element of chance, or they accept the fact that the laws will apply as soon as there is some element of chance. Would you say a predominance test is still justified, and why do you think it's justified?
First of all, I've yet to see a predominance test that is very scientifically accurate. And even if you see the predominance as the way courts around Europe have applied it, you actually see different results coming out from courts themselves. So the lack of a scientific method is already a problem in itself. I think a predominance test is still very valid, but I don't think in general it can stand on its own. In fact, when we wrote our skill game laws in 2016, what we looked at is a combination of factors. One of them is the predominance test, but there are 12 other categories that we take into consideration when assessing whether something is going to be considered a skill game or a game of chance, and even if it's a skill game, whether it's what we call a controlled skill game or a non-controlled skill game. So there are different parameters of how to go into it. So it could be, for example, whether there is a prize or no, whether it's a P2P activity or no, and the risks involved. There are 13 categories within the law that help us actually determine that.
Thank you very much. I would like to invite everybody to join me in giving a hand to Michele Magro.